The Alternative Dig Talk. Real issues, real talk.
Are you craving for that special meal that will entice your taste buds and leave you with lasting thrilling memories? Look no further. Spice Island Bulenga has got your answer. Natural, fresh and delicious juice, the best meals. Don't miss our daily specials from Monday to Sunday. Pizza Wednesday, Saturday Pizza Bonanza, you buy one and take two. Come dine with us and feel the experience. We are located at Prime Shopping Center in Bulenga, Mitiana Road. For inquiries, call us on 0704111720. Spice Island, we treat your cravings.
The Alternative Dig Talk. Real issues, real talk.
Good morning, our viewers. You're most welcome to this show. This is Tekachi, airing live from our studios, the Alternative Digitalk or Digitalk TV, and we are streaming live on our Facebook pages, the Alternative Uganda and Digitalk TV. Later, our show is uploaded on our YouTube channel, and those who cannot access it on Facebook Live, then they can find it on our YouTube channel, the Alternative Uganda. Secondly, is that our show is always interactive, and we bring to you different people, different guests to talk about different topics that are so insightful, that are giving knowledge to different areas of interest maybe, and different laws, so that you can also be encouraged to keep yourself in the know and find out how things are run outside there in the world, especially where you are not so much involved. And today we have Counsel Innocent Kabahima, and we shall be discussing the implication of this new bill that Parliament, I guess they are bringing it before Parliament for the second reading today. That is the Anti-Homosexuality Bill 2023. We have to remember that this is not the first time they are tabling or passing this bill. It was passed first in 2014, and then a group of people, group of lawyers, human rights defenders challenged it in the Constitutional Court, and it was nullified. And among the reasons for its nullification, we had the lack of quorum in Parliament when the bill was being passed. But we shall dive so much into that, and we shall see how best we can make you feel and understand its implications, what are the new terms, what are the do's and don'ts that we should know before we can even be caught off guard by this new law. And to give a legal alert this week, if you all remember the demonstration, I should call it the peaceful demonstration against the OTT by, among others, the Raymond Mugisha, Bobby Wine, I think they had APAS and so many other people. Yeah, Raymond Mujuni, not Mugisha, sorry. So they were arraigned before court, Uganda Road. And then the trial magistrate referred the matter to the Constitutional Court, to have the interpretation of Section 5 and 10 of the POMA, Public Order Management Act. And then yesterday, I think, or the other day, Constitutional Court halted all the proceedings in that matter. So that's a new decision of the Constitutional Court that most of you should get interested in and find out. But I should welcome Counsel Innocent to also say hello to our viewers and introduce yourself, and then we can start the discussion today. You are most welcome to Dig Talk.
Thank you very much, Bwana Kato. I am called Innocent Kabahima, like I've been introduced. I'm a lawyer by profession. I'm attached to Angualia Busiku and Co advocates. I am a Christian. I am an African. And so I intend to delve in this discussion on all those dimensions.
Okay.
I am glad to be here, and I'm glad that we have viewers out there. A good morning to you all.
Yeah, thank you so much. As he has introduced himself, but what is so interesting is that he had to also mention that he's a Christian. And I believe today we are not discussing matters of Christianity, theology, and the rest, but specifically matters of the law. And what the law says, actually what the bill says. And like I introduced our topic, we are looking at the implications of the new anti-homosexuality bill. And we shall be taking it through a number of clauses in this bill and what the Member of Parliament, Honorable Wassarilwa, is suggesting, and what the Parliament maybe will come up with at the end of it. Because this draft bill guides how the law will look like at the end. I am very sure that they will make some amendments after making the consultations, but this will most likely guide how the final act will be. And then we shall start from there. When we talk about this anti-homosexuality bill, and then to begin with, I want to say that we have some other laws that help in fighting against this, we should call it vice or habit.
Yes.
Did we need this anti-homosexuality bill in the first place?
Okay, thank you for that question. From a legal perspective,
Exactly.
I believe yes, it is true, we have laws that prohibit the act of homosexuality. Particularly, we are talking of Section 145 of the Penal Code Act that criminalizes unnatural offenses. And homosexuality has been categorized under unnatural offenses. However, we have very many aspects of homosexuality that Parliament is bringing up that are not adequately addressed in the laws that we have. We have very many aspects that we actually feel that Parliament is not properly addressing with the bill as it is. So there is need for that bill, and perhaps there is need for more discussions in regards to making it more comprehensive and more prohibitive of all these kinds of homosexuality that we are faced with.
Okay. So you will believe that we needed this new bill?
I believe that, yes, we need a law that is more comprehensive, and Parliament is bringing to us this bill. However, I'm also of the view that we could have done this by properly amending the Penal Code Act to make it more comprehensive.
Exactly.
That is
add
also
some of these new vices that maybe are not comprehensively handled under the Penal Code Act.
Yes.
Section 145.
Yes.
So that we can have a well-detailed law. If I may take the viewers through the interpretation section, clause, that is the first one. When a bill is being brought, we see some terms here. And this actually caught my intention and my mind that I felt we should have our viewers to get to know about it. The definition of homosexuality meaning same gender or same sex sexual acts. Yes. Then the other one is sexual act. Now, the sexual act is defined to include A, the physical sexual activity that does not necessarily culminate in intercourse and may include the touching of another's breast, vagina, penis, or anus. Yes. B, there is stimulation or penetration of a vagina or mouth or anus or any other part of the body of any person, however slight, by a sexual organ. Then C, there is an unlawful use of any body or organ by a person on another person's sexual organ or anus or mouth. Then now, we look at the meaning of a sexual organ now. It means a vagina, a penis, or any artificial sexual contraption. Yes. Then, when we come to the definition of the touching that has been talked about above. It includes touching with any part of the body, with anything else, through anything, and in particular includes touching amounting to penetration of a sexual organ, anus, or mouth, That is the meaning of the touching. And to say, because we have instances where this touching can be authorized under the laws, should we say that the person trying to come up with this new bill is not aware of such kind of instances where such touching can be authorized and not criminalized?
Yes, of course. I would answer that question by saying that 99% of the law is logic. Okay. So it is the test of reasonableness will definitely be applied, not only in enforcement, but also in interpretation. And like you read, there is where it says touching that amounting to penetration.
Yes.
Yes, something of that sort. So definitely, if it is simple touching as we know it, then there would be no penetration. Or if it is simple touching as we know it, we know what is offensive and what is not offensive. And we've always had these debates about sexual harassment and all that. And we know what is appropriate touching and what is inappropriate.
Inappropriate touching.
Yes. So I believe that is a matter of reasonableness. And in implementation, it is something that cannot really be a big issue or a big deal.
Okay. When we look at Section 145, the penalty for offenses of unnatural acts or
unnatural offenses, yes.
Where we can also put homosexuality, it provides for life imprisonment. In this new bill, the punishment provided now is 10 years imprisonment. Are we trying to lessen the penalty, or what are we trying to come up with when we suggest such kind of a penalty?
Thank you. Now that brings me back to my earlier submission that we perhaps needed to have amended the Penal Code Act to include these offenses, because you see, when you bring a side legislation, then you have a problem of equivocating, double speaking. You know, we are going to have a law that is kind of not so clear.
The duplication.
Yes, for instance, now we are already not clear on the punishments. Of course, someone would argue, that it is upon the DPP or the Office of the Director of Public Prosecutions to know under what offense to charge a particular person. But you see, there is also a law that prohibits the existence of two offenses against one particular act. So it is somewhere in the Interpretations Act. So definitely, it is going to bring a lot of issues in terms of implementation. Therefore, I agree that with some of the people that have been arguing that it would have been better that we have to amend the Penal Code Act rather than bring this particular legislation. I believe all the aspects that the legislation covers are valid, because there are very many aspects that are not covered under the Penal Code Act.
Okay.
Yeah, but it is also possible that they could have been brought under the Penal Code Act, and without necessarily having to bring the new bill.
Okay. So, Counsel Innocent, I want you to take us through some of the clauses in this new bill that you feel maybe are coming up to make it clear, and then to have the offense of homosexuality criminalized as a new bill.
Okay, thank you. Now, here, homosexuality has been brought in very many aspects, not only the act. Many people understand it as just the act of penetration, like you have said.
Yes.
But when we look at the bill, it has been brought in very many aspects. One of them is the act itself, as we have said. The other is promotion Then there is a dissemination of literature that is, promoting
Related to
homosexuality.
homosexuality.
Yes. So when you look at the memorandum of the bill, it's one of the objectives to establish a comprehensive law, comprehensive and enhanced legislation to protect the family. And not only the family, but to protect our African values and beliefs. Not only the African values and beliefs, but to protect our religious values and beliefs.
Okay.
Yeah, so when you look at it is prohibitive in very many respects. One, it prohibits sexual relations between persons of the same sex. Secondly, it prohibits promotion of same-sex relations.
Okay.
Yeah, and then it also comes to strengthen the capacity to deal with the internal and external threats to the traditional family. And it also comes in to protect our culture, like I've said. And then it also has in the aspect of protecting the children and the vulnerable groups, and to also provide compensation for the victims of homosexuality. Those are basically the key aspects of the bill in summary, in a nutshell.
Yes.
Yeah, so, but like we had already talked, you know that there are some of these aspects that are already addressed under the Penal Code Act.
And other various laws. Actually.
Yes, and other various laws. Now, like same-sex marriage, you know that it is prohibited under the marriage, because the Marriage Act is very clear. It defines what marriage is between man, between female and male. Yeah, but however, you know that much as it defines what marriage is, it does not prescribe a punishment. So there is also a need for a law that is comprehensive. However, that comprehensive law, as we are arguing, it could be brought under the amendment of the Penal Code Act. Yes.
Okay, you have now talked about something that is so interesting, and like I was reading through, there is under clause 2 of this bill. Clause 2, then C, talks about the offense, what amounts to the offense of homosexuality, and it includes touches where a person touches another person with the intention of committing the act of homosexuality. And we must be clear that there are two elements of a crime. There is the intention, the malice aforethought, and then there is the act itself, the actus reus. Are we trying now to criminalize somebody for their intentions that we don't know at the time?
No, but then there are attempts. When you look at the for attempts, you don't have the actus reus doesn't necessarily have to be there.
Yes.
So under attempted homosexuality.
So that's a different clause itself. But this one is trying to bring the definition of what amounts to homosexuality. And now the intention, when you touch somebody with that intention, and of which intention I should think it is left to courts of law to determine
yes,
the extent of your intention itself. And that's why I'm bringing this issue.
So perhaps those are some of the loopholes that we are already seeing in the bill. Some now that, for instance, it could basically have been handled under attempts.
Okay.
Attempted homosexuality. Yeah, because that is an attempt. The act has not happened.
Because the mere touching of somebody does not amount to the intention of driving them to the act of homosexuality.
There is an act of touching. If the bill is intending to prohibit the act of touching, then that is not an attempt. It is actually an offense.
Now I'll give
because
this
the
example.
actus reus becomes the touching.
I will give this example, and it normally happens in places that have a little bit of congestion and so many people. I will talk about like the markets, the tax parks and the bus parks and the rest. And that even in places of happenings, the bars and the rest, where people are congested, and somebody touches you. So are we criminalizing such acts as well? because we don't know the intention of that person who is touching you.
Of course, like I said in the beginning, there is that sense of reasonableness that must be applied. So really,
Are we
no
not
way.
leaving it hanging in that?
No, it is not hanging.
Didn't we need something that is actually more clear on where such kind of intention should be, looked into and considered, and some other places that are acceptable?
Now that is, we are going into the role of the prosecution and the court to determine, because for them they have mechanisms they can use to determine whether you had the intention. So once it is presented before court, there are mechanisms to prove that. However, like you say, reasonably, there are circumstances that you see that that will not really bring such matters to court. Now, like you say, in a market, really, if someone touches you accidentally, there is no way you can claim that now that is. But we know that there are instances whereby someone can do it in a way that they intend to do it, in a provocative way. There are people, there are hotels, these homosexuality activists and people who practice such acts. They have very many ways how they do their things or how they promote their things. They are based in hotels, they are based in very many places that we go to. So you could be in a hotel and perhaps someone approaches you and touches you inappropriately, and you feel it is inappropriate. So shouldn't we have such a person protected? Should we refuse to protect such a person merely because there is that accidental touch that may happen in the market? So I believe it all comes to reasonableness. Once it is presented before court, there is always a burden on prosecution to prove. And prosecution will properly extinguish that burden. And if it wasn't reasonable, then there is no way prosecution will extinguish that burden.
There is where I was reading, I'm forgetting the exact clause, where it talks about the evidence by a single witness that needs collaboration. Now, in an example that you have brought, for example, you are in a certain hotel and somebody inappropriately touches you, maybe with that intention of dragging you into homosexuality, and we find that your evidence shall not be sufficient, it alone, it needs to be corroborated for the offense to stand against the person you are choosing of. In such circumstances, now, are we not limiting this bill to a certain extent?
No, actually now that addresses...
Because in most of the sexual offenses, the victim themselves are the key witnesses. And now this one tries to bring a new test, maybe, on how such evidence shall be brought before court.
Yeah, that is not a new test. Actually, it has been, it is a test in evidence law.
Yes.
That has been there for long. And you know that even in these rape cases, still, court cannot convict on the basis of the testimony of the victim alone. If it
but
is not
they are the key witnesses in such kind of offenses.
So it is not something new. And that actually answers what the issue you raised earlier regarding the those reasonable touch and what is unreasonable, because that would in a way also help to prevent a floodgate of cases, people claiming here and there over, because at least if you don't have enough evidence, then you will not come to court.
Okay.
Yeah, so that in a way would address that question that you already talked about. That is one of the mechanisms. However, I find that not really strange, because we know that there are people who can frame charges against the others. Yeah, so there are very many laws, there are very many reasons behind that rule of the in evidence law that courts should not rely on the testimony of a single witness. Because if, for instance, I used an example of a hotel, someone attaches an inappropriate, there are many other ways you can prove. It doesn't necessarily mean that you have to be the only person. There are many other ways you can prove. There are people at the hotel. They could be possible witnesses. There are usually cameras. So definitely there will be other ways that you will use to corroborate. You could take a statement from him that where he contradicts and incriminates himself. So there are very many other aspects of bringing evidence before court.
Under clause 3 of aggravated homosexuality, it talks about where a person commits an offense of aggravated homosexuality, where a person is charged with the offense under that section, the person shall undergo a medical examination to ascertain his or her HIV status. And in the petition that was filed before the nullification of the 2014 bill, some of the issues and the grounds for that petition included the mandatory testing of HIV of people. And the petitioners were stating that this is actually deprives the people's privacy. And we see it in this new same bill. Did we make a duplication of what was happening the other time and what is happening now? Or did they have any other changes so that we can avoid the same bill if their interest is actually to have the bill in place, not being nullified on the same grounds of discrimination and deprivation of people's privacy as they are right under the Constitution?
Okay, but I think the reasons as to why the 2014 bill was nullified are clear. There was lack of quorum in passing that law.
But there were also other grounds that corroborated the lack of quorum.
Those were not the grounds that court basically based on. The ground was lack of quorum.
Yes.
So, and when it comes to, for instance, the test of HIV, that is something that has already been there because HIV, it is one of the circumstances that aggravates the offense. Just like in aggravated defilement under the still the penal code, still there is that element of HIV aggravating the offense from simple defilement to aggravated defilement. So definitely, if you're suspected, they will have to take your results. It would be maybe what would be infringing on your privacy is if they are taking these results to publish them.
Of course,
but they are taking your results for court
purposes. Also, you are taken to court, and we see that in this bill there is a clause that talks about making them public, and they should be in camera so that the public gets to know. And then when they are charging you and the evidence is being brought to prove that this was aggravated, then your HIV status must be stated anywhere, somewhere in the evidence.
No, obviously when they
where does it leave your privacy? Even when we know that under our Constitution, there is that presumption of innocence. But here in the trial, then your HIV status is revealed to the whole world to know. Doesn't that deprive you of your right to privacy as an individual?
No, I don't think it does. Okay, yes, it brings out the fact of, let's say, you having HIV into the light. However, it is necessary for purposes of prosecuting that offense. Because you see, if we are going to debate to claim for rights, privacy, all this, then there are very many things that we are not going to achieve, especially in our justice system. Yeah, for instance, if you claim that, you know, I am still innocent and then that means someone wouldn't be arrested in the first place. That means someone wouldn't be taken on, you know, handcuffs, because that is also the infringing on their right of being, you know, derogation from their being treated inhumanly. So sometimes rights have to be limited, of course, to achieve a particular purpose.
Okay.
So I find that really justified because there is an intention that is being achieved.
Okay, clause 4 here talks about an attempt to commit homosexuality, and it says it provides for the punishment as for 2 years, imprisonment for 2 years for attempted
homosexuality.
Is that sufficient?
And of course it is not. It is not. And one of my one of the problems I have with this bill is that I find the penalties being too low. And I don't know why because when you look at the previous bill or the previous act, because it had been passed, it had more grievous punishments than what they are now. I don't know whether they are succumbing to some kind of pressure or what, but I would suppose that this is an issue that touches us as Africans, that touches us as Ugandans, and therefore if we are legislating it, we should legislate it with the intentions of Ugandans, not necessarily any other particular person who coming from wherever. So I find those punishments being too low, and that is one of the grounds as to why I was just seeing an opinion of the Attorney General. That is one of the grounds as to why they are saying it is actually not proper that we have a new law when we have a penal code that we can amend,
and include all these.
Yes, and include all these, because we cannot have the penal code prescribe a bigger punishment and then this bill comes up and it is lessening the punishment. That is not proper.
And under clause 5, protection, assistance and payment of compensation to victims of homosexuality. Clause 1, sub-clause 1. A victim of homosexuality shall not be penalized for any crime committed as a direct result of his or her involvement in homosexuality. Then there is where something that I feel is okay, consent of a victim of homosexuality. Consent of a victim of homosexuality shall not be a defense under this act.
Yes.
I feel that is a little bit okay.
That is very good, because you will not bring up a defense that, I did it and the person had consented, because again it goes to how we see it, we see it, and the objectives. Like we say, the objectives is to protect the family, the traditional family, to protect our values. So
and maybe here something
cannot
also
consent to breaking our moral fabric, and then you say that for me it was my consent.
There is something also under clause 5 that talks about compensation of the victim. I think this is something good, maybe, but I feel this one should also be limited. People who are forced into committing homosexuality, but if a person is interested in involving himself,
then those ones would be prosecuted. Both of them would be prosecuted. So you cannot.
Then clause 7 talks about confidentiality, and that at any stage of investigation or trial of an offense under this act, a law enforcement officer, prosecutor, judicial officer, medical practitioner, or any other party to the case shall recognize the right to privacy of the victim.
And that is what you are talking about when you are talking about privacy. You see, there are aspects under where the right to privacy can be limited, but there is where the law also acknowledges that it is fundamental and it should not be curtailed in any way. So those few aspects where it can be limited, it will be limited. But where it cannot, for instance, it talks of the victims. Now, there is no point of exposing a victim, really, who has been victimized. There is no point of exposing them. That's why, when it comes to court proceedings, they said the court proceedings shall be in camera.
Yeah, where the court finds it appropriate. That's what the bill says.
And not in open court, because in open court it means that even the public would be permitted in.
Yeah, so it continues and goes to editors, publishers, reporters, columnists, and in case of printed material, announcers, producers, in case of TV and radio, and most of that. And they continue to say that a director of a film, in case of a movie industry or any other person utilizing trimedia facilities or information technology, who publishes or causes the publicity of the names of the person, circumstances, or any other information tending to establish the victim's identity without authority of the victim or court, commits an offense and is liable on conviction to a fine not exceeding 250 currency points. So this means that there must be authority and consent of the victim, or even court.
Yes, that
court
again,
orders for the names to be published, then
that again protects the privacy.
the privacy.
Privacy.
Then we have under Part 3, related offences and penalties, Clause 8, aiding and abetting homosexuality. And it talks about, now this is where I think most of the people are getting issues with this bill. It talks about a person who aids, abets, counsels, or procures another person to engage in acts of homosexuality, commits an offence, and is liable to a conviction, on conviction to imprisonment for 2 years. Now my issues here, and I would want to get your view on the same. If somebody is trying to counsel people, maybe about the dangers of homosexuality, maybe about if it has advantages, maybe he's trying to counsel them about the advantages.
Let me see the spelling of counsel.
It is the real counsel, like giving counseling. That's about Clause 8.
Clause 8.
Yes, it's here, Clause 8 around. And it criminalizes such an act. And counseling involves a number of things.
No, counsel. This counsel, it is not really. It doesn't really mean that you sit down someone and then you counsel them again. Of course, definitely, if you're counseling them against homosexuality, that is okay. But there is that counsel like advice. Counsel is like advice.
Yes, this is the advice.
So you're advising someone to engage in homosexuality. You'll be penalized.
And where it is actually being promoted and procured, oh, you are aiding the act of homosexuality. Is this punishment, imprisonment for 2 years reasonable for that offense? Because I believe the whole essence of homosexuality is through promotion and aiding, maybe supporting the people.
And that's where the big problem. For me, actually, to some extent, we wouldn't even mind, because you see, for us, we are more concerned about our values as Africa. To some extent, we wouldn't be concerned if you come from wherever you've come from abroad, and maybe you're in your hotel room and you do your things and we do not know.
But as a country,
but when you come and now you start promoting them in our midst,
if I may ask,
you start engaging our children in schools to be part of such. I believe that's where the bigger problem comes in. So definitely, the act of promoting, the act of procuring, the act of or disseminating such information is something that we should not treat lightly. 2 years, I already gave my opinion on that. It is something that is really too small for, even if it is about aiding and abetting, it is something really too small that I wish Parliament could find ways of revising these punishments and at least making them more grievous. It would be better.
Then there is, under Clause 9, there is conspiracy to engage in homosexuality, and a person who conspires with another to induce another person of the same sex by any means of false pretense or other fraudulent means to permit any person of the same sex to have unlawful carnal knowledge of him or her commits an offense and is liable on conviction to imprisonment for 2 years. Conspiracy.
Conspiracy, it's also an offense.
And false pretense.
Conspiracy, you are, how do they call it in Uganda? You know, where you sit and you come up with an idea, or you come up with
an idea and
then you execute it, or you aid other people to execute it. That should also be punished. Those are all aspects of homosexuality that.
Clause 10, procuring homosexuality by threat. I think this is a little bit clear. And now we go to Clause 11, detention with the intent to commit homosexuality. Clause 12. Now this one also raises a number of issues. Clause 12 talks about brothels. And a person, is the effect that a person who keeps a house, a room, set of rooms, or place of any kind for purposes of homosexuality commits an offense and is liable on conviction to imprisonment for 7 years. That's a person who keeps a room or a house.
That's also an aspect of homosexuality.
Then B, a person being the owner. Now this is where the whole issue comes in. A person being the owner or occupier of premises or having or acting or assisting in the management or control of the premises, induces or knowingly causes any man or woman to resort to or be upon such premises for purposes of being unlawfully or carnally known by any man or woman of the same sex, whether such carnal knowledge is intended to be with any man or woman, any particular man or woman commits an offense and is liable on conviction to imprisonment for 1 year. We have instances of landlords or caretakers, or I don't know what they are called, who keep premises, maybe on behalf of the others or the rest. And we have tenants who come with their, I should say, habits or intentions that are not disclosed at the same point. And when I read about this clause, it seems it also affects the person who now lets me in their premises with the intention of maybe using them for homosexuality.
Yes, and that is criminal, because if I let you in my premises to use them for homosexuality, like you say, because there is a qualifier, when you read the entire statement, there is where it says where he does it with the intention or induces other people.
Or knowingly causes the
so
person
if you're a
to stay on the
landlord,
premises.
much as you're not staying on those premises, but you have your premises, you let them to people who you know are going to engage in homosexuality, or you procure people from wherever, you put them in your premises for purposes of engaging in homosexuality, then you also be punished under the new bill.
Okay, I guess the caretakers of the houses, the landlords, are now taking
Yes, you're a
interest.
caretaker and you know what is happening.
Clause 13 talks about same-sex marriage. The person who purports to contract a marriage with another person of the same sex commits the offense of homosexuality and shall be liable on conviction to imprisonment for 10 years. Now those are the people that are contracting marriage. Then we go now to clause 14 that talks about promotion of homosexuality. And a person who participates in production, procuring, marketing, broadcasting, disseminating, publishing of pornographic materials for purposes of promoting homosexuality. B, funds or sponsors homosexuality. C, offers premises and other related fixed or movable assets for purposes of homosexuality or promoting homosexuality. C, uses electronic devices which include internet, like the one we are using, films, mobile phones for purposes of homosexuality or promoting homosexuality. And then it talks about the punishment being imprisonment for a term not exceeding 5 years or a fine not exceeding 5,000 currents. Now the issue comes in because it is not clear on what amounts to promotion under this clause. For example, today we are discussing this bill. Can someone use this same as promotion? Because we are broadcasting information and literature that is related to homosexuality. Can we be...
Good, you've added something to do with broadcasting.
Yes.
However...
And it is also included
yes,
in...
Yes,
we are broadcasting and disseminating the information to the public. This information relates to the literature that maybe talks about homosexuality. Can we be criminalized under this act? Because it is not clear.
We are talking...
And it does not create the test
no.
and the yardstick on
no,
how...
but we know the intention. The intention of Parliament is to... The intention of Parliament is to curtail people from promoting homosexuality. For us, what we are doing is not promoting. Instead, we are decampaigning homosexuality. So that you cannot be penalized for decampaigning. The law talks about promoting, disseminating information that is promoting homosexuality, not decampaigning.
But looking at the level of
or not talking about homosexuality, talking about something is not really. It cannot be punished.
Be amounted to promotion.
No.
Because when you look at the level and the conduct of the investigators that we have in our Uganda and the police itself, it's very hard for them to actually realize that what we are doing is not promoting. Before you know it, you'll be arrested. You've been in cells for 2-3 days or weeks, and then when you are paraded before court, then the court will say, no, that was not promotion. Where you have been arrested and you have suffered loss and damage and the rest.
Of course,
so
wasn't
it necessary for this parliament to make it clear on what amounts to promotion? Maybe in the interpretation section and say...
It is clear. It is clear enough. It is clear enough. Broadcasting, disseminating literature that is promoting. There is a difference between talking about and promoting.
It is actually, let me repeat this. Clause 14, 1A, talks about a person who participates in production, procuring, marketing, broadcasting, disseminating, publishing of pornographic materials. What are we discussing now? Doesn't it qualify under
publishing pornographic materials?
And broadcast.
Continue.
For purposes of promoting.
Exactly.
And this is why I was bringing the issue of the investigation levels that we have. And you know their qualifications, with all due respect.
But you see, we cannot really refuse to legislate on the basis of we have those lapses in our justice system. I would say we cannot refuse to sleep merely because we fear nightmares. So definitely, those are challenges that we have that we can find ways of dealing with at another stage or in another discussion. But the law is clear. The law is clear, and the primary custodian of the law is the court. So once you go to court, it will, like you said, it will rule appropriately.
But where you have suffered...
that is a discussion we can have on another day.
Okay, let me take you through the comments and see whether we have a few questions here to answer and respond to.
Okay.
Jeremiah, thank you for watching. And this one asks, I don't know whether it's a question, let me read it and we can get. What could have been the reason why Honorable Basarwa couldn't propose amendments but rather considered a new bill? At some point, I am convinced that our MPs live in ignorance where it comes to all existing laws. That's why they propose new laws, even when there are other old laws that would simply need amendments. But that aside, there are so many laws that are never enforced. You remember the law against polythene bags? In fact, all police canteens sell more Vera than other shops. That is our view are saying. Should we say that our MPs lack knowledge of the existing laws? That's why they rush to come up with bills.
For that, of course, perhaps there are those who are knowledgeable, there are those who may not be. But I believe it is also because he also has reasons as to why he chose to, because we also have particular offenses that have been legislated against specifically.
Okay.
For instance, we have anti-corruption. We have the Anti-Corruption Act.
Yes.
That is against corruption. So someone could have argued that perhaps there is somewhere a provision in the penal code that we should dwell on to criminalize corruption. But they found it more appropriate that let us create a special legislation that criminalizes corruption, hence the Anti-Corruption Act. So perhaps the Honourable Member of Parliament could also have had that in mind, that this is a very broad issue. Like we've seen, there are very many aspects we have discussed there, that if you need to amend, it would really,
be easier even.
No, it wouldn't be easier to amend the penal code, for instance, to say that you're going to add in all those pages, all those. So you choose to say, let us create a law on a side. So I don't want to really dwell so much on the intention of the particular member of parliament who brought that, but I believe it is also right in some respects. However, for just the reason as to why, for me, I personally, I find that it would have been better to amend the penal code is to avoid such inconsistencies, because you see, perhaps the ignorance could have been in regards to the punishments that are already existing being applied against the punishments that are, because now we are having laws that are equivocating, like I said.
Okay, this one says, in criminal proceedings we have seen where one, upon conviction, is liable to imprisonment, fine, or both. My personal opinion is that government should equally consider awarding monetary compensations to victims of, let's say, rape, defilement, or even murder. Not to sound weird, but there is no way a broke parent or victims will report their abusers, especially if there is room for the culprit to buy their victims off. To a layman, they will consider being bought off by their abusers simply because even if the government clinics, even if the government imprisons the offender, all the victims get is simply a painkiller from the government clinics, and that's all. We have seen parents to the defiled kids fail to treat their kids, or even transport to court during the trial. For such reasons, parents have considered receiving money from the offenders and let go of the case. I think this is a very serious and sensitive issue that must be considered. And especially when we are coming up with such kind of new proposals for the bills.
Perhaps it's the reason as to why they put a provision on compensating the victims. So the activism could be that the same is done in regards to other offenses like rape, like aggravated defilement, and
this
so
one,
I think that is really a fair assessment.
It's called Conrad. Don't you have other problems in Uganda than discussing the stupid law day after day? I think our intention is to create awareness to the people about what is being brought before Parliament and as a law. At the end of it, or whether we call it stupid or not stupid, when it is passed as a law or as an act, it will affect all of us. And it's better that we have knowledge about what is being introduced. Maybe we could get room and get knowledge of how to challenge it better, and not simply calling it stupid at this stage.
Perhaps
thank you for that.
Perhaps I would agree with him, is that we shouldn't give it much attention, because you see, the more we show these people that, we are debating, the more they feel like, we are going to be accommodative at some point. We should agree that this is typically an African, this is typically against our values, and there is no debate to have against it. It is unnatural, it is criminal, like we have already said in our laws that we already had. We considered it unnatural. So it is a crime, and therefore it should be criminalized in all respects. And we should have no
Conrad continues and says,
debate every now and
Conrad continues and says, one gets the impression that you all love homosexuality so much that you have to talk about it every day. The government and the parliament have other tasks. I don't know of any country where the issue is permanently discussed by politicians and in parliament. Yeah, a little bit maybe. This one says, Counsel Kato, about promotion, you need to advise our government that over 80% of all the imported movies have homosexuality characters and scenes. I hope the government will deploy a team of technocrats to prevail all imported movies before entering the Uganda market. And I agree with him 100%.
That is also
leave alone the imported movies. We are in an era of technology where internet provides each and every kind of materials that every person is interested in knowing. So, as we almost come to the conclusion, did we need this as a new bill, first of all? Or do we need laws to bring the society into what we believe in as a country or what we believe in as Africans? Do we need a law on each and every matter that comes in at play in the public.
Yes, we need the laws to protect ourselves. We need the laws to protect ourselves because, you see, without a law, you cannot say that we live in a society of lawlessness. That would let us descend into anarchy, which we are not yet to really agree with. So we need laws. We definitely need laws. That is not...
Have the laws that are in place helped also in solving these problems? Because we have a number of laws that criminalizes so many acts. And we have the same acts repeatedly being done by even big people in offices, by even old people, by even intelligent people. And it questions the extent of how the laws can solve these problems.
Yeah, perhaps what we need more, aside from the laws, we need implementation of the laws.
Okay.
Yeah, we need proper implementation. Implementation that is not biased, that is not one-sided, that is not, that is fair. We need implementation of those laws. Perhaps, you see, because when you look at that provision in the Penal Code, Section 145, it has been there, but it has not been implemented. The implementation is what has been lacking, but the law has been there. So we perhaps need to attach implementation to these laws that we have in place.
Okay.
And then we need to boost those laws. That is the reason as to why this bill is coming up, to boost what is already there. Yeah, though, like, of course, we have already said it would have been better that that kind of boost is made within the Penal Code Act and not necessarily coming up with a new law. Yeah, but the point is that we need the laws.
Okay. As we conclude, I'll give you like about 2 minutes, 2 or 3 minutes to give your closing remarks.
Yeah, and the other aspect that perhaps we did not, the bill does not address, and I feel that should be addressed, is in regards to custody arrangements. You see, when you, it is like saying that we are protecting our goats from being eaten by hyenas, and then when you arrest that hyena, you again keep it amongst the goats.
Okay.
So we having to prosecute these homosexuals or whatever, and then we put them amongst the our other prisoners.
The other prisoners.
I find that really problematic. So I wish in coming up with that bill, they should also put a provision on perhaps having separate custody arrangements for such people.
Will there be schools now of homosexuality?
Schools?
Because if you bring the people that believe in the same ideology together, and are you not encouraging them to keep doing it more and more, even everywhere they find?
Perhaps we can find ways of dealing with them there. So, but I find, because for them, they are not really victims. If they are put together and they keep doing their things, of course, we can find ways of also addressing that. But the entire idea of separating them from these other convicts would be to protect the other convicts.
The other one,
because much as they are prisoners, but they also have to be protected, they also have rights. They also have to be protected against such vices.
Okay.
Yeah, so, and my closing remarks would be that, I agree that we need such laws to protect against to protect our families against this vice, to protect our culture, to protect our institutions. We are Africans and we know what we believe in, and these people who are promoting it should know that we as Africans, we existed before the Europeans came, we existed before the Arabs came, we existed, and we had values, we had beliefs, we had norms, we had our tradition, which needs to be respected. So in coming up with these laws, there is a video that I was watching where some so-called activist was busy throwing words, abusing our minister, that is Mr. Bahati. Throwing all words that, it's like you have nothing to do, people are dying of this and this, you're there, you're misrepresenting Ugandans. And I'm like, no, this is someone who was, actually I would say, expelled from Nigeria because he claimed he was almost being lynched in Nigeria, so he went to the US, that's why he's staying, and he's basing from there, to attack. And I'm like, we are Ugandans. We have sent these people to legislate. and and we are the ones who elected them into power. They are doing what we want. Then for you, you're basing from the US to come and say that, we do not want this, you're misrepresenting you. So I think that you must also find ways of, doing off with these kinds of so-called activists.
Okay.
Yeah. So thank you so much, and thank you, the viewers.
Okay, thank you so much, Counsel Innocent, for that lengthy discussion and so interactive and so knowledgeable. I hope our viewers have been able to capture one or two words from this kind of conversation. But to say, as I come to the conclusion of this show today, and this is my personal opinion, I've heard so many people talk about the issue of morality and, to deal with our African setting and the issue of Uganda and the issue, so many things related to that, religion and the rest, especially when you're talking about issues that relate to homosexuality and the people that believe and practice it. To say I am not personally involved in the acts of homosexuality and the rest, and I don't think I am about to be part of them. But my issue is, where do people get the moral authority to discuss issues relating with homosexuality and call them more such bad and terrible acts, and then get involved in the scandals that are even more worse than homosexuality? For example, stealing the iron sheets of the Nide in Karamoja, being corrupt each and every day, getting involved in torturing the Ugandans, mismanaging all the resources of the country, and then tomorrow they are on TVs and they are in parliament talking about morality. I think you are the first people to be immoral, and you lack the moral authority to talk about other people who believe in what they do. At the end of it all, you should be involved in fighting all the morality, regardless of whether it falls under the sexual immorality or the personal immorality. Morality is morality at whatever level, and what you believe in, you should be the example and not talk about immorality on one side and then get even involved in morality of things that affect the common Ugandans. See you next week, Tuesday. Have a lovely afternoon.